Thank you so much. And with that, I'd like to invite others to participate. I'm very happy to see our incredible attorney, Wendy Murphy, is here. If anybody wants to argue about any legal things, please ask me and I'll pass the question along to her. And yeah, we're going to win this. We are going to win this fight together. Thank you.
Thank you. Wow. Well done, Kamala. Thank you.
Thanks, Sanja. Tina, do you have any questions from the chat that you'd like me to address?
I don't see any yet, but I welcome them. And I'm also, if people want to unmute themselves to ask questions, that would also work at this point, if that's possible. I think it is possible to unmute yourself, because I just did, but let me know.
I'll just say that in the next week or so, we're going to have a link. So if you go to either equalmeansequal.org or finalimpact.org, you will be able to upload your picture and join the campaign, the portrait campaign, the Inside Out Equality for All. And for anyone who's part of a larger organization, I see the ERA North Carolina Alliance is here. Jimmy's here. Hi, Jimmy. I see different organizations here. They are very, very welcome to participate in this Inside Out project, because the more local groups pick it up, the more difficult it will be to ignore. Now, we can only hit maybe 8 to 10 of the battleground states, but it doesn't mean that it cannot happen in every state, and that will be facilitated by Equal Means Equal and the Inside Out project. Are there other let's see, here's a question.
So Kamala, there was a question.
Yes.
Forgive me. Yeah, there was a question about funding, how much. So we have a deck that we can send you privately, for sure. I think it was Jimmy that asked, how much are we raising? But in short form, we are raising $350,000 to get the first bigger installation done. And then to go into the battlefields, we believe it will be about 1.1 million. We, of course, we've got, we're talking to a lot of people. People are slowly donating. So it could be $5 to 100 to 300 to $1 million. It doesn't really matter, but really that's where we are today. And we're beginning our first dinner in New York City, in LA next week. So I just wanted to throw that out. But we do have a deck, and it will all be broken down of the how. But really, yes, it is a multimedia campaign. So it will be spreading globally throughout across America. So I believe we have done a very good job on making sure that it's not $5 million. So Jimmy, if that helps, that's where we are today.
So one of the questions here is, are there other effective ways besides phone messages to leave with Colleen Shogan? I don't believe Colleen Shogan is the correct target, because she has stated very clearly that she will do nothing unless the president directs her to do it. She has also stated very clearly that if the president does tell her to do it, she will. So all we have to do is tell him to tell her to do it. And the only way to get him to do it is to get him scared that we're going to make things very difficult for him. And I know people are scared about that, but understand we must achieve equality in the Constitution. We cannot continue to rely on political parties and different politicians. They've strung us along for 100 years. And at a certain point, we have to stop getting played, and we have to make the play. And this is the play. It's called Make the Call, Joe. And not to speak out of school, but we are in talks with the White House. We are informing them of what we are doing. And they are aware of this campaign. And if they believe that this campaign is going to be hugely successful, they will attempt to co-opt it. And we've made clear that the only way that the Biden administration can co-opt this campaign is by first publishing the Equal Rights Amendment. If they do publish the Equal Rights Amendment, not that we can tell anybody how to vote, but we can certainly educate the public with the same infrastructure we've set up now, that this thing has happened, that the president did make the call, that you now do have control over your body, that you now do have recourse against your rapist. So it behooves the Biden administration to immediately publish ERA so that we can get behind them and help them instead of being in an adversarial position, which is where we are right now. How do states get involved and organize? So as soon as our page is up, which will be any day now, certainly within 3 days, there will be a page on the equalmeansequal.org website and also on the finalimpact.org website, which will explain to you exactly how to create your own equality for all action in your state if we are not already going to that state. So right now we've identified 6 battleground states, but we're looking at 10. And note, each battleground state has its own budget that we have to come up with. So, and that's what Sanja was saying, it's all broken down. It sounds like a lot of money, but frankly, for what we're going to do, it's extremely frugal and extremely pointed, and it will be extremely effective. And I remember about 15 years ago talking to a Yale colleague who went to McKinsey. I said, I want to get the Equal Rights Amendment done. And he went to McKinsey and they did a study and they came back and told him that to get the Equal Rights Amendment ratified was going to cost $150 million. Well, I'm here just 15 years later, and we didn't even spend $1 million and we got the thing ratified. So imagine what we can do with a very small amount of money. Look, the United States rips off women to the tune of $1.6 trillion a year. And that's just government agencies paying women less than men. So we should be able to pull off a few $100,000 to make this right and get women paid properly forever. Arlene, does Biden's promise to codify Roe fix all laws against reproductive? No, so clearly this codify Roe thing is a complete red herring. It's misstating. They know that without the Equal Rights Amendment, they can do nothing to prevent states and bad actors from controlling women's bodies and lives. And that's what's so disturbing as well, is that these are not people that are fools. These are people going on reproductive rights tours and promising to codify things that they know full well they cannot do. And so we do have to stand strong, and we do have to be brave enough in the face of the pressure, being told that, you know, your choice is to put up with, you know, to go along with this candidate or face the devil himself. Well, no, the choice is to stand strong for women after 101 years, get this done so that we're in a position to help make everything better. Josie says, your hope is to get state number 39, 40, 41, etc. The theory that this keeps the ERA in the public eye. So there are states, I know New York State is fighting very hard to get their ERA done in their states, and that's great. But the fact is, the truth is, the Equal Rights Amendment is presently federal law. It is presently part of our Constitution. That cannot be taken from us. You cannot rescind states because you now decide that all those people that voted for it, their votes mean nothing, and now you want to change it. No, we have these rights. If the states want to continue to get more, that's great. It just proves that the ERA is not controversial, that 96% of the public wants it, and that if we're not getting it, it's because we're presently living in an unconstitutionally governed quote unquote democratic republic that is not operating either as a democratic republic or a constitutional, following the Constitution for all their supposed care about the Constitution.
Can I just do a follow-up then?
Yes.
So when can a court case be tried on it? Does it need to be published before the courts will recognize and hear a case?
No, I don't think so. We are doing it. In fact, Wendy had us file interventions in 2 cases in Texas. We're filing an intervention in Nevada right now to use ERA, whether it's the state or federal ERA, to say, no, you can't do this. But our concern is, because publication is such a fussy little thing, it's not, it's kind of like the way they get away with it. They're like, yeah, I see it's ratified, but I don't see it. It's not in my book. Well, it's not in your book because it wasn't published. And as soon as it's published, it gets in the book. So every constitution printed after publication has ERA as the 28th Amendment. That's why publication really for us now has to be the main focus, the thing that we just say, look, it's easy. There's, it says Article 5 says, upon ratification of 3/4 of the states, the amendment shall be adopted.
Absolutely.
And that's what we need.
I have a prediction that it's going to come down to personhood versus womanhood. Petri dish, embryo, fetus versus woman. And I've been wondering why we don't maybe get out ahead of that news and make that an argument. Will it chase us or can we chase it? I'll go mute.
I think this is a Wendy question because honestly, I don't even feel qualified to answer that. Wendy Murphy, please.
Yeah, sure. I mean, I'm happy to answer it. It's a really good question. It's an important question. States right now have the power to give personhood, meaning to give rights to fetuses, regardless of the stage, literally from the moment of conception, up through 9 months of gestation. The problem is that because women aren't yet equal under the Constitution, though we do have personhood, we have second-class personhood. So it's really easy for states that want to control women's lives and bodies to characterize women as the same as the unborn, because here we are at second-class personhood, and then they give a kind of personhood to the fetus, and we kind of look equal. And once you have that, once you have women looking like they are the same value, human value, as unborn people, they can do whatever they want, and it always becomes a balancing test. Well, we got to take into account how the woman feels. We got to take into account how this unborn baby feels, and we lose every time. Is the point. The reason the ERA is so critical on the issue of abortion, among many, many arguments, is that it bumps us up to here, and therefore, no matter which states pass laws to give personhood to the unborn, we always win. Right now, we don't always win because we're not considered first-class persons. We need first-class personhood, and I call it first class. I just mean we need equal personhood with all other, humans and that are born. And until we get there, we are essentially on par with a 1-day-old, barely gestated pregnancy.
I totally agree. And I feel like that may be the battle that comes. And I'm just wondering if we can get ahead of it and say the value of woman is greater than a petri dish. And you've got to grant us this, considering the balance, considering what the alternative is.
You mean to use that argument now to help us get publication? Yeah, well, one of the things, as Kamala said, we filed a brief in an abortion case in Texas where there's a 6-week ban, and that's being litigated now. It's actually pending before the Texas Supreme Court as we speak. We got involved in that case, filed an intervention brief to make exactly that argument. Under the ERA, women are persons with fully equal rights, and an unborn fetus is a thing in which the state has an interest, but it's not a person. And we can make that argument only because we used the ERA as the basis for our position. We filed a similar brief I'm not sure it's even filed. It may be going in Monday or Tuesday, but in Nevada. Basically, the whole point of writing these briefs is to reframe the debate and to reframe it through the lens of the ERA, and then use everybody's paying attention to these abortion cases. So we're using the abortion cases that everybody's paying attention to hammer home how important the ERA is. Now, our briefs are arguing the ERA is already valid, as Kamala has said so eloquently. For sure, there are people arguing in these same cases, wait a minute, it's not even valid, but that's okay, because we are at least shining a light on the value of it being validated, the importance of it being validated, and that there's a reasonable disagreement about whether it's already valid. In a sense, we're taking advantage of these cases for our purposes, but also doing it to make really good arguments on behalf of women. And in the two cases I mentioned, where Planned Parenthood, I'm sorry, the Center for Reproductive Rights was the lead attorney in the Texas case. The Center for Reproductive Rights, Planned Parenthood, and the ACLU have all been involved in some of these cases, or many of these cases, as the attorneys for abortion rights, speaking on behalf of women. And they're not even arguing that women deserve that maximum level of legal equality and maximum legal protection for their rights. They're not making the argument about women are persons, and the fetus is a state interest, but not a person. So we've been force feeding the arguments, both because it's really good for this ERA battle that we're undertaking right now, but it's also to embarrass people who claim to be speaking for women's rights and aren't making those arguments that deserve to be made. In a sense, we've accused these people of committing malpractice against women by not arguing that they deserve that higher status, Josie, that you mentioned. So we're fighting on a lot of fronts, and we're going to continue to file these briefs from now until November, because everyone's paying attention to abortion. So we're going to make them pay attention to our views about the ERA and abortion.
Thanks for all you guys are doing. Appreciate the answer.
Does anybody else have any questions? So I'm very grateful. Oh, go ahead, Jimmy.
I just posted something to Wendy. Would you mind commenting on the decision in Pennsylvania about that was based on their state's ERA and abortion?
Oh, thank you so much for giving me the chance to say this. For those who don't know, and even if you already know, I think we should talk about it. There was a decision at the end of January of this year from the Pennsylvania Supreme Court addressing the constitutionality of a new abortion restriction. I think it was a Medicaid funding issue. But the point is, every state has some kind of restriction, either a ban, 6 weeks, 15 weeks, a funding restriction. All the states have different restrictions, and most of them are being litigated under state constitutions. Well, not all of them are being litigated under state ERAs. Remember, what Kamala's been talking about is the federal ERA. The beauty of the federal ERA is that once it's in place, we don't even need state ERAs, because the federal ERA would create that maximum legal protection, that full standard of equality that women deserve. But between now and when the federal gets settled, some of the states have good ERAs that already give women that high standard of equality. Some states have ERAs that look good, but have been interpreted as allowing the second-class treatment of women. And those states would also benefit from the federal ERA, because the federal ERA would prohibit states from interpreting their state ERAs in that second-class way. So, there's a lot going on as this chess game goes, but here's what the Pennsylvania court said, and it's really good news for both other states that are debating what law to apply from their constitutions to these abortion restrictions. What provisions are they going to use to analyze whether these new restrictions are constitutional? The Pennsylvania Constitution has an ERA that is worded exactly the same as the federal ERA. Not all states do. Some language in state ERAs is a little bit different than the federal ERAs, than the federal ERA. But the Pennsylvania ERA is exactly like the federal ERA. And what the Supreme Court said when addressing whether it's constitutional to restrict public funding for abortions is, not under the ERA, you can't. Now, mind you, they weren't talking about the federal, they were talking about the state, but because the language is the same, it gives us a wonderful way to argue about the importance of and the value of the federal ERA. And what they said was a couple things are really important. First and foremost, they said, forget what Alito said in Dobbs about how we don't even have to think about women's equality as a question when analyzing the constitutionality of abortion, because abortion and pregnancy and reproduction are not sex-based concerns. The Pennsylvania Supreme Court basically said, Alito, you're an idiot. Because of course reproduction and abortion and all things related to pregnancy, of course they are sex-based. They happen on the basis of sex. They involve sex-based part. I mean, the court was so simple about it and said, without being rude to the Supreme Court, made clear that the Supreme Court is out of its mind to say that pregnancy and abortion are not sex-based. Of course they are. Then they moved on to the next question. Well, since they're sex-based, what does that mean? What can our Pennsylvania state ERA tolerate in terms of restrictions on those sex-based concerns when it comes to construing the nature of the concern, which is a fundamental right, and obviously not just a fundamental right to control your body, but the restriction itself is discriminatory, sort of separate concern. So what do we do when there's a discriminatory restriction on a fundamental right under the Pennsylvania ERA? They said, you can't do it. Absolutely not. Under no circumstances can you restrict a woman's right to public support for abortion because you fund everything for men's reproductive concerns. So there's that comparison. And they also said, again, to reject Alito's view of the issue, where Alito and the Supreme Court said the reason it's not a sex-based concern is because men can't get pregnant. The Pennsylvania Supreme Court said that's a canard. The fact is, it doesn't matter that men can't get pregnant. And by the way, the Pennsylvania Supreme Court also acknowledged that, of course, trans people and people that are non-binary and people who identify as male and female, you know, the definition of who can get pregnant is not as black and white as it may have been years ago. So the Pennsylvania Supreme Court said, of course, this covers LGBTQ, covers all persons. And let's not get, you know, ridiculous about these categories of who can get pregnant. The court said, regardless of who's claiming an interest in having their rights protected, the act of reproducing is a sex-based thing that happens. So because this discriminates, which is to say it restrains a category of people based on sex in terms of their ability to access public funds, because it is discriminatory, we will review it under the strictest legal standards. There has to be a compelling state interest in the restriction. It has to be narrowly tailored to serve that restriction. And it has to be the least restrictive means to serve, well, to reach that result. These are kind of weird legal concepts. But what the court said was, the state doesn't have a compelling interest in the unborn. It's an important interest, but not a compelling one. Win for us. Only under the ERA is that a win for us. That the restriction is not narrowly tailored. Even if the state could show that it has a compelling interest in protecting the unborn, this is not the narrowly tailored route to do it. Just categorically take money away from people who can't afford to get an abortion. It just doesn't jive with their goal of protecting whatever the important state interest is in unborn life, or, you know, however they want to frame it. And of course, there's no question, but that they could protect their interest in the unborn less restrictively, which is to say they can do it without taking money away from people who, without money from the government, can't get an abortion at all. It's, in other words, you're killing an ant with a grasshopper if you're trying to serve the state's interest. And you have to do it narrowly because the ERA requires a very super narrow tailoring in order to make sure that you don't step on women's rights 1 inch more than you need to protect your interest in the unborn. So basically the Supreme Court of Pennsylvania destroyed the argument that any kind of restriction on abortion can be tolerated under the Equal Rights Amendment. And again, because it's worded in exactly the same way that the federal ERA is worded, we've been using the Pennsylvania case in our other cases. We put it very much up front and center in our brief in Nevada, which is going in this week. And now we're trying to say in as many other states as we can, have you heard what Pennsylvania did? And do you understand that if the federal ERA is law, which of course we argue it is, then you need to take it into account when you, whatever state it is, decide the constitutionality of the 6-week ban, the 15-week ban, or whatever the bans are. There's about 20 lawsuits pending around the country, all involving some kind of new restriction on abortion. And every single one of those cases, the people arguing for abortion rights are using state constitutions to get it done. They're not arguing the federal ERA, we are. And even when they're arguing under their state constitutions, some are ERAs, some are state due process provisions, some are state privacy rights provisions, all from their state constitutions, but they're picking and choosing which ones they want to use. We are only making an equality argument. And we are fiercely using the federal ERA and arguing that, of course, it's valid. Congress has already proposed a resolution declaring it valid. And if Congress says it's valid, then we're correct. I mean, we have so many good arguments, but we're going around the country saying, this is a hot issue for women politically during this presidential election. And everyone's going to turn to these state courts and look at what they're doing when analyzing what's at stake for women. We are trying to force them to examine the answer to that question through the lens of equality, because it's really the only thing that matters. Equality is the lens through which abortion rights should always be analyzed. And we haven't always done it in the past. The Supreme Court used privacy rights, some kind of penumbra, due process. We are squarely using equality. We're taking advantage of the opportunity to put the ERA out there and, in a sense, force these state courts, some of whom have already said publicly, their governors and others have said, like Nevada. Nevada ratified the ERA in 2018.
2017.
I'm sorry, 2017. Nevada was the first to ratify after the deadline. And now we are in front of the Nevada Supreme Court saying, of course the federal ERA is valid. You ratified it. You can't use the deadline against us. You ratified it in 2017. So it's wonderful to be in front of the Nevada Supreme Court. It's not that we're going to win. I hope we do, but we're going to shine a light. And the importance of the Pennsylvania case, thank you for the question, Jimmy. The importance of the Pennsylvania case is that it has given us a light years more authority to make our argument about why the ERA saves Roe, why the ERA protects abortion rights. If you just read Dobbs, you would have no idea that abortion has any bearing on women's equality, because it's not there. And Alito dismissed it in a footnote. If you read the Pennsylvania Supreme Court's decision, which is 200 pages long, and that's not with the dissents, all it is about equality. It's a beautiful decision that everyone should know, and it should be studied and read and used, force-fed into every court in the country, especially between now and November.
Thank you, Wendy. Wow. Well, I think we have a lot to chew on. I'd like to just end by entreating you to please consider supporting this campaign, amplifying this campaign. Please send an email to info@equalmeansequal.org, and one of us will get back to you right away. And do keep an eye on our websites to see how you can participate in Inside Out Equality for All, the new JR/Equal Means Equal project, to make sure that Biden cannot escape staring at all the people's faces wherever he goes, whatever state he's in. We're just saying we want equality, and we need you to pick up the phone, Joe, and make the call. And with that, I'd like to thank you all so much for coming, sharing your time. Thank you to Yale. Thank you to Tina and Maria. And to all of the equality activists and classmates and colleagues on here today, I'm very grateful for this opportunity, and I hope you have a wonderful rest of your evening. Thank you.